Okay, let's go ahead and get started. There's 140 people on. Electra and I are going to make exceptionally good use of your time today. I'm going to share my screen and we're going to be talking about the contract intelligence layer. The agenda is very simple. We're going to start with the story. I think we owe this to you in terms of what it is we're building and why it exists. So we'll spend a few minutes there. I have a ton of slides, but I'm just going to breeze through them very quickly. And Electra will chime in here in particular. Then I'm going to get into the demo. So you will see what it means at this stage for us to bring context into your drafting and review process. We'll also be very transparent and talk about pricing as well and just say what it looks like to bring this into your organization. And then at the end, my colleague Dory, who is off video but is very much here, is going to share an application with you. So if you like what you see today and you want an opportunity to test it out, we'll give you that. The reason that there's an application is not a sales and marketing tactic, or maybe it is a little bit, but it's mostly not. What it is that because we are integrating your context and your precedent into the negotiation experience, we want to make sure that you're ready for that, that you know what the data is, you know where it is, and that we've jumped through the hurdles from an info security perspective, et cetera, which we will talk about today also. Without further ado, Electra, if you could introduce yourself briefly, and then I'll do the same, and then we're going to jump in to this presentation.
Sure. Hi, everyone. Thanks, Preston. I'm Electra. I am the Chief Product Officer here at SimpleDocs. I'm also a lawyer. I've worked very closely with Preston over the last few years to get to where we are. Prior to this, I founded One NDA, and this is really a continuation of that premise, really, because since the beginning, my mission has been to standardize and streamline the way that we review contracts, and it's been such an honor to have the opportunity to work with Preston on this and bring technology into it as well. So very excited to show you what we've built today.
Yeah, thank you for that. And I see Sylvia reporting an echo. If others are reporting an echo issue, let us know. Apologies for that. I'm not hearing it on my side, but others may be. No echo for me. So yeah, sorry, Sylvia. We'll see if we can help you get that resolved. My name is Preston Clark. I'm the CEO and co-founder of SimpleDocs. In a previous life, I was the creator of LawInsider.com, which many of you are probably users of, and I'm grateful for that. And then in a previous life to that, I was Assistant General Counsel at the University of Miami. Carol, go Canes. Um, let's jump into this today. For those of you who may have been on a webinar with Electra earlier this week, we talked about how we bring context at the sort of intellectual level into the drafting and review process. And intentionality comes into play when there's lots of AI tools available to us. What do we use and how do we make the most of it? Um, the tools that we build are used by law firms, but our primary use case, our primary customer is corporate in-house legal teams. I don't want to alienate anyone on the webinar today, but we build primarily for corporate in-house teams from a feature and functionality perspective. And we think that the precedent is going to, that which we'll show you in a minute, is most valuable to this audience. Business wants speed. Legal needs context to deliver speed. Something that Electra mentions a lot is that we all went to law school, and either before law school or the result of law school became very fast readers, and very good at reading comprehension and synthesizing information. And so the speed gap is not us. The bottleneck is not us as lawyers. The bottleneck is often our access to the information we need to make decisions. And in transactional work in particular, that is across what we think is really three vectors, and we're going to be talking about that today. So it's not a people problem; it's a system problem. And the moment that sort of that you have is not what does the market do? It's what do we do? It relates to what have we done in the past? What are our policies? You care about market also, and we have a good answer for that. But a big thrust of it is in the moment, do you have sufficient data and context to make an informed decision? And so often the answer is that you don't, that this information exists, but it requires channel switching. It requires you to go to other places to find it. And that's the challenge that we've been working on. Knowledge is fragmented. The knowledge that we think is most important in the negotiation is market precedent. Externally speaking, is what I'm looking at standard. This is different from what's market, which we can debate and discuss at a later date. But the idea is, are there things in this agreement that shouldn't be here? Or are things missing from this agreement that would normally be included in it? MSA, DPA, cloud services agreement, whatever that may be. Policy is, what are our rules relative to this agreement type? What is our position on choice of law or dispute resolution method or SLAs, etc.? Where are these codified and how do I access them instantly? This is where a lot of legal AI has been focused in the last year and a half or so. It's an area of focus for us. And then organizational precedent. This is what I'm going to be live demoing today. This is magical from my perspective because this was not possible before, at least not in any elegant way of what it means to bring specific negotiation history just in time into a contract review where you can get a sense of whether or not what you're being presented with has been accepted at a high rate or a low rate in the past, and the ability to filter by contract type, by vendor relationship, by recency, so that you're getting a very exacting answer and recommendation that then you can use your legal judgment to make a negotiation decision. The converse of doing this, the why, the ROI, the business case is what happens when this is not available to us, right? And the reality is these are pain points that I'm sure you all are head nodding against what's on the slide here. It takes some time. And in the worst case, we just go off of gut because we don't have time and we've been at the firm or we've been at the company for 15 years and our gut is pretty good. But that is not scalable, and even that is imperfect. And so the idea is, how do we overcome some of the challenges and hurdles? Make policy thresholds visible, makes market range visible, make organizational history visible, reveal deviation patterns, preserves decision reasoning. That part at the bottom is important because a lot of sort of the AI skepticism or maybe excitement relates to Uber. Like the Uber thesis, to cross compare for a second, is that eventually there'll be no Uber driver, right? And maybe AI gets to a point where all of us are out of jobs, but I don't see that future anytime soon. What I do see, however, is the need for context at the moment you need it so that you can make informed decisions to use your legal judgment on how to accept, reject, modify what's being presented to you. But in order to do that, and this is really important to Electra and I, it's really important to our product organization, is that word visible or verifiability really comes into play. Because as we're talking about bringing context in and helping you make decisions, we're not asking you to blindly trust SimpleDocs. We're giving you the ability to verify that information, whether it's public contract data where I can go through and see what contracts have informed that decision, precedent. Let me see the contracts that like you may look at a red line and it says we agree to this all the time and you can't believe it. You're like, I've never seen us agree to this before, but the tool is telling me 70% of the time we do. Let me go verify that. This verifiability becomes the trust standard that allows you to make confident decisions. And then of course, policy is precedent. We've done this for very well, and many of you are probably users of this. Codified playbooks that exist inside Microsoft Word, so that you can always verify and understand how that decision is being arrived at. What is it that the policy what is being defended through the AI based on your policies? I'm going to skip through this because I want to get to the live presentation. I'm going to move through this very fast, but how these things stack is we think of market standards at the bottom. That's really important. We think of policy threshold. What do we accept? What are our fallbacks? How do we escalate? We think of organizational precedent, which we've been talking about. What are the outcomes? What are our deviations? How has this worked in the past? And then we think about accessibility, which is where is this data presented? Because it's not as if these things don't exist to us. It's not as if market data is not present, or that we don't have policies, or that we don't have any organizational precedent. You do have it. The reality is, though, is it's not in one place, and it's not at the place of negotiation and drafting where you would ideally want it to be. Drum roll, please introduce the contract intelligence layer by SimpleDocs. What this means is we bring these together inside the Word add-in in a way that is elegant and just in time and verifiable. So this is what today is about. So we're going to look today at precedent. This is not the demo. This is just a screenshot. I will give you a demo in just a moment, but it's about bringing precedent into the Word add-in. It's about bringing policy via playbooks. And again, many of you have seen this and are already consumers of this through SimpleDocs. And then it's market standards. I'm going to give you a glimpse into this today, but this is what Electra, as our chief product officer, is working so hard on. Listen, we spent 15 years building Law Insider, the largest public contract database in the world. We source data from over 50 countries, over 50 languages, cross jurisdictions, and we use the data points from that data to help inform your negotiation decisions relative to whether or not something is standard or not. This is coming. I'll give you a glimpse into it today, but we are just at the tip of this part of the story from a standards benchmarking perspective. I'm going to get to pricing later. I'm going to stop now and cut over into the tool, and we'll do a live demonstration. While I'm getting ready, if there's questions in the chat, happy to answer those. But Electra, if there's things you want to add at this point as I'm switching gears, feel free to jump in.
Thanks, Preston. Um, I've written a lot about this and I've thought about this in a lot of detail, but effectively, what creates bottlenecks in an organization when it comes to legal is not the fact that, as Preston said before, we're slow readers. We're very fast readers. We're very good at consuming information. And what happens in practice is that you're reviewing an agreement and you're making so many different judgments in your head, and you never have the right context there and then when you need it. So if you want to know what's market, you will either go to Law Insider and search for it, or you'll call a law firm friend and ask them, what's market. And so to bring all of this together creates an efficiency that is, I think, is going to be transformational, and also the thing that really helps legal adopt AI in a fundamental way.
Yeah, thank you for that, Electra. Um, Welcome to Simple AI. What I'm going to show you today is an overview of the tool in its full feature set capability. For some of you, that will be redundant, so I will keep it brief. But the part that is new, the part that is most important to you today, is what's on top where it says precedent review. For those of you who already have SimpleAI or SimpleAI Pro, your version of this banner is probably going to lead you to a marketing site where you will book a meeting with our sales team. Um, the reason for that, precedent review is different from our other products in as much as it requires a data set in order to be used. And so it is not an off-the-shelf product. Similar to playbooks, we can have a standard playbook library, but we don't know your playbooks until we help you build them. And so precedent review has a couple of steps that are required, and we'll, as we get to the end of the presentation today, you'll have an opportunity to apply for early access to this, as I mentioned at the start of the webinar today. I'm going to come to precedent review in 5 minutes, so please allow me 5 minutes. We have plenty of time. We'll probably, hopefully even be able to give you a few minutes back today. We will jump into this in a minute, but let me orient you to the rest of the tool. 5 minutes. Okay. Document review sits on top. Redline, draft, compare, general review. This is no playbook required, no policies required. It's a wonderful tool. It's actually the most used set of capabilities and features. As much as we've invested in playbooks, a lot of people just come in here for rapid analysis, rapid redlining. So let me just show you quickly what that looks like. If I have redlining turned on, I can quickly go in and say something like, make sure choice of law is Washington State, if I can spell it. And in this case, what it's going to do is it's going to analyze the document, see what it has for choice of law. And in that case, if it's not Washington State, it will propose change. And at that point, I can apply that change and it will redline the document or I can dismiss it. So it's a fast way to produce red lines just in time if you know what you're looking for. Conversely, if you have a drafting project or you simply are missing something in the document, so maybe you've used the AI to analyze and it's given you the feedback that it's missing a liquidated damages clause, I can say, please draft a concise liquidated damages clause with a 40, 50K cap. Now, I know many of you are not in the US, so apologies for using US dollars. This is jurisdiction and certainly currency agnostic. This is the first place we've integrated the law insider relationship. And so, what you will see here as this language is being drafted, two things are happening. We're pinging off of the Law Insider database looking for liquidated damages clauses, and we're pinging off of the large language model to produce custom language that is based on the document that I have open and based on the prompt instructions I gave. I could certainly modify this to make it more favorable to one side. I could change the dollar amount. So similar to any AI tool you may use, you can continue conversing, but every time you do that, it's going to continue pinging off of the Law Insider data set. And so at the bottom where it says see all, to go back to the theme of verifiability, this is where I can see similarly structured, in this case, liquidated damages clauses um, in in the public domain in Law Insider. Now, I can also say, because I know this is a global audience on this call, please rewrite if I can type here, please rewrite this in Spanish. And in this case, it will produce that for me as well. And it will also score the document again, because we have a global database. We've been doing it for 15 years. It's massive in size. And it will, oh, it's actually doing a whole agreement. I wasn't specific enough. So I'm flexing a different muscle now. I've literally translated the entire MSA. That was not my intent. I wasn't specific or clear. I should have said, give me an indemnification or liquidated damages in Spanish. So let me just do that really quickly. I need a liquidated damages clause in Spanish with a 50K cap. And so what you'll see now is it will produce what was happening before in English. It'll give me some instructions in Spanish if that's what I want. But the same thing is going to occur at the end where it will once again score and it'll show me examples from the Law Insider public domain. Third use case I want to share briefly is that if I'm not drafting, I'm not redlining, and I'm not comparing, I can also just talk to the document. I could have it do a risk assessment for me. I could have it produce a work product. So I could say I need an email for counterparty that summarizes my red lines. So this document has a few red lines already, and it will produce this for me. I could have also asked it to do this in Spanish or Japanese or French or any language that is suitable. And it may not have the appropriate salutations. We are launching a style guide soon, though, so you can have some additional context that at the style guide level you'll be able to add in. But this is a really good starting point. I can also use this to produce work products. So if I just needed a memo that was analyzing the risk, or I needed a table to be created that would give me some overview that I could share with a colleague or a general counsel, that is available as well. I'm going to switch over to playbooks briefly, and then I promise we'll get to precedent-based benchmarking. I'm not looking at questions. I don't know if Electra, if you're seeing some, I see some pings coming in, but if there's anything that I should double click on, feel free. We have about 205 people on the call, so there may be more questions than I can get to. But if there are good ones, I'm sure they're all good. But if there are good ones, I'm
Yes.
happy to answer them live.
Yes, we do have a couple of good ones. Can you put in something as general as can you provide other provisions that you would suggest to make it enforceable in Montana and that would be more favorable to the service provider? Um, Yes, you absolutely can. So that's what the ask feature is for here. You can highlight any clause and ask it to do something specific. When it comes to asking the tool to align something with a specific piece of law, I would just say yes, but verify it. Verify that the output is aligned with your actual requirements, because saying things like the laws of Montana or the laws of England and Wales is so broad that you might get some noise there that you want to filter through. And then the other question is the tool capable of analyzing MSAs from a variety of MSAs drafted by different companies for signature by our client? Lawrence, that's a great question, and Preston will be going through precedent momentarily, and we'll be going through that use case as well.
Yeah. Yeah, that's great. And to illustrate, I was trying to look for a clause that would, um, you know, let me see if I can use taxes. So I could go in here and I could literally go to red line mode, highlight taxes and say, something like, make this more concise. Not even really a good recommendation, but what you can see in the box where it shows selection, it's now proposing a change specific to that clause only. And in this case, I said more concise. I don't suppose that's going to be a sort of red line use case you'll use, but you do see as a result proposed changes that will strip down this from a few sentences to a couple of sentences.
Thanks, Preston. Could you talk to us a bit about security and data and storage of contracts? There's a question around whether the document being reviewed becomes part of our database, and the answer is no, but I think there's a broader piece here around security.
Yeah. So thanks for that. So um, SimpleDocs, one of the oddities of SimpleDocs sitting on top of Law Insider is that there can be confusion for some users because you see us being very good at publishing public contract data. That is very much a resurfacing of public data, not a republishing of your data. I will show you in a moment, as after I get through precedent, um, our trust center, where you can see information, including that we're SOC 2 Type 2 compliant, that we're GDPR compliant, that we have a zero data retention policy as it relates to contract analysis. Obviously, if we're your precedent library or if we're your repository, you would expect us to store your data, where we have the highest compliance standards, and our customers are global publicly traded organizations through which we've gone through rigorous due diligence evaluations, and this includes the U.S., it includes Europe, it includes the Middle East, it includes Canada and beyond, all of which have their own distinct compliance regulations. We even recently passed a compliance standard for Texas public organizations. It's called TextRamp. I don't suppose many of you know what that is, but we go through the steps to make sure that your data is protected. Okay. I'm not going to show you compare, but if you have access to this or if you get a chance to use it, it is wonderful. This is not so much about version tracking, but it is very much about the ability to upload two or more distinct documents that need to be reconciled. So you could compare a third-party MSA against your own MSA. You could compare a term sheet or an LOI against a purchase agreement or a sale agreement. And it'll give you a rich analysis or even give you red lines if that's what you want. So compare is a great feature to test. Won't get into it today in the interest of time. General review, I'm going to do a quick overview of this. And Electra, if you want to share some information as well, that would be awesome. But generally speaking, to double use general, this is a great starting point when you don't have a playbook, when you're reading a contract, you get stuck with some tech transfer agreement that you've never seen before, you have no basis for, and we don't have a playbook for you either in our standard library. This is a great starting point to basically create instant analysis and red lines based on market standards. So, Electra, if you want to add any color on that, I'll give a shot at running this.
Sure. So What the general review feature is great for is for when you don't have a standard playbook in the library that totally aligns with the agreement that you're reviewing. The quickest way to use playbooks is to go to our standards library, which we'll show later. We have 55 standard playbooks, and you can use those to review any agreement. That's great when you've got a really standard agreement that you want to review and when the playbook that we have aligns with your needs. But when you don't, and you just want a quick overview of your agreement, what you need to do is go into general review. Now, the first thing it will do is that it will ask you about your role. And it's important to role frame whenever you use any AI tool because then it knows which side to be on. In this instance, if we tell it we're the customer, it will make sure that the playbook that it creates thereafter aligns with your interests. You can add any specific concerns you have here. For the purposes of this, we won't, but if you have specific concerns such as we don't accept non-solicitation or I want to make sure that the IP clause is really tight, you would put any context here. I'd also advise that you choose highest quality to get better output, but again, for the purposes of this, we're going to go fast. You can either continue and get a full strategy of what the tool's going to do so that you can tweak it, or you can skip and start review, which is what we're going to do today. Now, what the tool's going to do is it's going to look at your agreement and pull out, sorry, we've gone with strategy, which is great. So what
Sorry.
the tool's now, that's fine, that's fine. And what the tool's going to do now is it's going to give you an overview of the points it thinks are important based on the context that you've provided, the nature of the agreement, and it's also drawing from what it thinks is fair and balanced based on the law inside a database. And this is an opportunity to redirect the tool if you think that it's off the mark. So if this looks good to you, then you go ahead and you generate the playbook, you start your review, and the tool will now start to build out rules. And these are the rules that underpin the AI generated playbook. Now, by the way, when you're finished with this, you can also save this. So this is a good kind of hack. If you want to quickly create a playbook, even though we have a dedicated feature for that, you can create a dedicated playbook that doesn't just take into consideration your own template, but also something that reflects what's more balanced in the market and that's probably going to cause you less friction when you go into a negotiation. So these are all the rules that the playbook's created. What you can do is you can immediately see where there are issues that the tool wants to flag. So for example, it's telling us that there is a unilateral modification right. And so it's proposing a red line that you can give effect to in order to align the agreement with your preferred position. So if you click on that, it will take you to the part of the agreement and you can see what's problematic. And that's how you move through a contract review with the playbook. So that's your general
Awesome.
review.
Yeah, thank you for that. And I'm going to briefly show playbooks now, and then we're going to jump over to precedent. Um, there's two flavors of playbook. There's custom and there's standard. They are similar. Um, the standard library is wonderful. Electra, in partnership with her community, including the One NDA community, were instrumental in assembling these. But they're not endpoints. They're expected to be starting points. And so, if I were to look, for example, at an NDA playbook from the library, I could select mutual. And then I can go edit it. I can save it so it becomes the top of my list. I can also edit it. I'm now looking at the backside of a playbook where I could go in and duplicate it and rename it and share it with the rest of my legal team. But now, more importantly, I can go term by term and modify it to the exact specifications of my organization. So if you're using this tool and you have the need for playbook execution, but either you've not taken the time to build out your own playbooks for which you have documentation, or you like this as a starting point and you're going to use your own to then tweak and modify or basically merge them together. It is very intuitive to do it. You can have very clear prompts and issue level instructions. You can have fallbacks. You can even have guidance notes, which is wonderful. I have a guidance note here that says, if we go to 2 years, we need GC approval. So if you're in a larger in-house legal team and have a sort of some new attorneys, some younger associates on the team who don't have as much business context in terms of a rule or what has to happen from an escalation perspective. And remarkably, our single most popular feature is comments that are auto added when the rule is flagged. This is sort of a hallelujah moment for a lot of our users who've invariably spent hours of their life justifying the same changes over and over again via comment. So these things can be carried over automatically. The running of a playbook is very easy and very elegant. So you select the playbook, you run it, and similar to what we showed you before in general review, it takes all of the rules that you've codified, all of the rules that you've approved, and it applies it to the document. I selected a random one. This is for AI and machine learning services agreement. That's definitively not what I have open here, but it gives you a sense of how it works and how it operates. And then you can go issue by issue and decide whether to apply a red line or other. Custom playbooks are easy to build. Electra leads our legal engineering function at SimpleDocs, and we have an incredible team, a global team of former lawyers like Electra and I, who've become AI experts and certainly experts in our software, who help build out and codify your rules. But you can also do it on your own. So you could start with a playbook from the library, as I just showed you. You could also build your own from scratch, issue by issue, or you can do it based on the existing document. So if you think that your MSA template is emblematic of the rules you want to defend with third-party MSAs or other, this is a great jumping off point. Probably gets you to 60%, 60 to 70% there, and then you can refine it. You may need to add things that are missing, etc. But Playbook is a wonderfully powerful tool. Okay, drum roll. I'm now going to jump into precedent review. This is the biggest new feature that we're launching and announcing today. And before I do that, if there are any other questions or anything I missed, Electra, I'm happy to take a beat.
All good.
Okay, let's look at precedent review. So here's how this is going to work. We will either integrate. There's 3 points of integration that are important to this tool. If you are a customer of SimpleDocs already and you have an integration with our repository, which is native for SimpleAI, then this will work seamlessly. And what's important about that is that it's real-time updated, because if you use us for repository, it's integrated with your e-sign tools or wherever contracts are coming through, which means that the precedent is real-time updated, which is super valuable. That's option one. Option two is you don't use us for repository, but you use us as a lightweight precedent library, which is just a storage for whatever you want to ingest as your precedent. And maybe you don't want everything to be precedent. Maybe you have a long-standing relationship with Coca-Cola and you have 250 contracts with them, and you just want that use case accounted for. We can support it. If your highest volume first party document is an MSA or an order form, we could just ingest that. But there's different ways to get to this precedent and establish that precedent. We can do this through integrations. And of course, we can do this through the Microsoft Word add-in as well. So if you want to do something project-based, you could upload, a couple of dozen or 100 agreements. I will pause here and say this is fundamentally different from a context window in sort of a general purpose LLM where you're going to upload 5 agreements and say compare. As you will see in a moment, this is meant to be permanent precedent that is integrated into a repeat negotiation cycle that you find yourself in, where the data is verifiable, to bring back the word verifiability. And so I will show you this now. So I'm going to click on precedent. I need to add precedent. I don't want to compare this document to the entirety of my database. That's not helpful because I have varying agreement types. I could select by party. So I have some companies that I work with at a high volume. I can select by agreement type. I'm going to do MSA because that's what I have up. Pretty soon, within the week or so, you'll be able to also filter by recency. So if I want to filter by MSAs for the past 3 months, if I think that's my strongest precedent, then I can give it that level of filter. I'm operating with a pretty small document set in this demo environment, but this could be much, much larger. So for today's demo purposes, I'm going to be comparing this MSA. The story goes, I'm the GC at Acme Corp. This is our MSA. It has gone out to the counterparty. It hit their counsel's desk. Counsel has redlined the document, and now it's back with me. And instead of going one by one and going off my gut in terms of how to approach these different things, what I'm going to do is I'm going to say, let me compare this to the other MSAs that I've reviewed and negotiated in the past X period. And so I'm going to go ahead and run the comparison. And now the analysis begins. It's going to look at these red lines. By the way, I just think this is mind blowing. And so I hope you do too. I think that I wish when I was a transactional attorney, I had this or that this technology was even possible. What's happening now is it's first assessing whether or not there's even enough data to arrive at some sort of informed recommendation. And in this case, I know that there is because we have a library of MSAs that we've signed in the past. Um, if there's not enough data, it will tell me. If there is, then we have a range. It's going to tell me if these red lines have ever been accepted in the past. And if it's not, it's going to sort of give me a red all the way to green, which is we commonly accept these. Now, going back to one of my earlier slides, we're very much keeping our lawyer hats on, our judgment hats on. This is about enabling you to make decisions faster. We're not going to tell you what to do. You would not accept that even if we tried. But what it is going to do is it's going to enable you to make some decisions relative to how best to deal with what is being proposed by the counterparty. And so that is our goal. That is sort of the outcome that we aspire to. And then you get to use your judgment in sort of deciding issue by issue, red line by red line, what is in the best interest of your organization. By the way, you may still have escalation points. You may still decide that based on what you've seen today, it's not conclusive enough. Maybe it's, sometimes accepted, but that's not a hard line enough for you. These are things that you can decide on your own. But this is where, of course, legal judgment comes into play. It's almost completed with the analysis, and we'll see this result in just a second. Are there questions coming in right now, Electra, that you're seeing?
I'm answering the questions as we go. If there are any questions that I think you need to answer, I'll mark those down so we can discuss them at the end.
Okay, that's great. I'm actually going to rerun this because it didn't propagate the way I expected it to. So I'm just going to rerun this one more time. Of course, when I'm on a live demo with 200 people, we would have a bug.
Preston,
Um,
can you
yeah,
answer this question in that case? Can the precedent library also yield comparisons of non-legal things like budgets, for example?
yeah, that's awesome. So long as you deem it to be precedent, and so long as that data is accessible to you, we would be able to incorporate it here so that you're getting a recommendation engine. If it is aggregated, like it's in a spreadsheet and it's like sum totals, that may be something that we would have to do a custom implementation for, but the core engine is here. So if what you want is a comparison, it can reveal that comparison to you. But if it's sort of outside of a Word document, we might have to get clever with how we implement it. Okay, it's working now, which is great. Sorry about that hiccup. So in this case, what it is identified is four red lines in the document. I can go verify that. It looks like, one, two, three, four. There's the fourth one there. And so that's great. And it's going to give me now a score. Again, not enough data at one extreme all the way through to commonly accepted, which is what it's doing now. So this one is the first one to come back. On top, I have commonly accepted. And this is the part that I think is mind blowing. And hopefully you're as impressed as I am. Although Electra and I spend probably way too much time looking at these solutions. But I think that this is about bringing context elegantly into your negotiating and drafting experience in a way that, was previously not possible. Um,
Preston,
okay. Yes, please.
um, a question. How does the tool gain access to previously signed contracts?
Beautiful. So there's going to be three ways to do that. And I'm going to answer that question first because it's a good sort of like first principle foundation question. And then I'm going to expand on what's on the screen now. So three ways. One, if SimpleDocs is your repository, that is not an obligation. You do not need to allow us to be your repository in order to use this solution, but that is path one. And this would mean that we've integrated with your other systems, with your e-sign tool, all the places where contracts are flowing through, and we become your repository of record. And this natively integrates into the tool. And then, as you saw before, when I was clicking on precedent, you'd be able to filter down by contract type, vendor, recency, so that you're not always looking at the entirety of your own repository. That's one. Number two is that we can just be your precedent library, a feature that we're launching next week. I would demo it for you now if it was here. You can literally go, there'll be a plus button right here. It's in beta right now, where you can upload and establish your precedent in real time right here. It could be 100 agreements, it could be 500 agreements, it could be, again, just your relationship with Coca-Cola, just your relationship with Walmart, and you can use that as a data set. Now that is not a project-based precedent. This is now a permanent, until you delete it, a permanent part of your precedent library. But this is fundamentally different from giving us or allowing us to be your full repository. We don't need to do that in order to give you access to this capability. So again, you can upload your contracts here. They become stored as a precedent library, and then you can pull from them in real time during your negotiation. Number three, and the one that probably everyone is waiting for, is we do have a native integration with SharePoint. We have integrations with iManage, wherever your G Drive, wherever your box.com, wherever your contracts live, we can also integrate there and surface this data through that. So we don't need, if your IT department's like, no way are we switching off a box, yeah, we don't need you to. But what you need, what creates utility for you is for us to integrate in such a way that the precedent can be verified as is presented on the screen now. So those are the three ways. Happy to expand on that further. Electra, you're smiling. Anything?
Yeah, some amazing questions. So I've got two questions that are basically asking the same thing.
Okay.
Um, so how accurate is the result? Meaning that contracts will have multiple forms and structures. Is the tool able to catch and compare these differences and detect all precedents in my stored agreements?
Yeah. So I'm going to give my answer and then Electra's going to give her. They're similar, but we love this question so much that we're both going to answer it because I think we have a couple minutes. So one of the superpowers of AI is semantic search and the ability to find intent rather than what we used to rely on, which was sort of if then language matching. If it doesn't say this exactly, then this, and we would have sort of 15 permutations of possible red lines and then hope the machine would give us a clear rejection or acceptance. So at the premise of it, what you're really asking is if the red lines aren't the same, like Delaware to Florida is easy because there's only really a binary there. It's either they've changed it or they've not. And if they have, they've probably just changed one word. It's different when red lines to red lines are very different. But structurally and foundationally, they're the same. And that's where AI is wonderfully powerful. And so the outcome there is that it will give commonly accepted as showing at the intent level, not the word match level, if that makes sense. There's one more thing I want to say on that, but Electra, let me push this to you first. If there's
Um,
more you want to.
No, I think you've covered it. That
Okay.
the fact is that we're now in a position where technology allows us to do a much deeper analysis of language, and that's why legal tech is at the next level. And we have the capability to give you quite a substantial and deep overview of the similarities, not at word level, as Preston said, but at substantive level.
Yeah. Thanks for that. And this is the other thing I wanted to say. When Electra and I went down the path of building playbooks, it's wonderfully difficult. I know that every large language model is claiming to be doing it perfectly now. I take issue with that because they're not. But when we went down that path, what we found was that playbooks are excellent for third-party paper review because you have a codified rule. We accept this, we don't accept this, term length must be this, choice of law must be that, SLA must be this. And to connect it back to your question, irrespective of how that rule appears in a document. Like if we don't accept liquidated damages clauses and there's one in the document, but it's not expressly stated as liquidated damages, but clearly it is, it will find it and it will reject it. Like that's a superpower because we've all reviewed thousands of MSAs in our life, but every one is a little bit different, which means we have to go line by line. And what's so powerful with AI is that it's rule based. So it will go find if that rule conforms or not, and it will flag it if it does not. That is wonderful for third party review. For first party red lines, it's harder because first party are your rules codified. And so any rejection of it is technically a rejection of your rule. And so now the question is, what do I do when my rules are rejected on my own paper? And in some cases, having a playbook with a list of policies is the right approach. But more often than not, what you are doing is making a value assessment based on what you've done in the past. 50% of the time, 80% of the time, 10% of the time, how frequently do we accept this range of SLA, of response time or uptime? What percentage of the time do we accept auto renew or unlimited liability? And there still may be escalation points. You still may need to take this to your CFO or to your GC or other. But we see this relationship between playbooks and precedent-based benchmarking as having a line in the sand and distinction between first party and third party. Hopefully that resonates with you all. It's something that, again, Electra and I spend a lot of time thinking about.
Thanks,
Okay,
Preston. We've got a question on pricing. And just quickly, if someone's performing work on behalf of different clients who may have different precedents, can you limit the precedent analysis to just the client's document set? Yes, the quick answer is yes. You totally can. And on PDFs and Word, we can use both PDFs and Word as your source. There's a question around whether PDFs can be picture PDF and will the tool OCR?
we are excellent at OCRing. We can get into that. So I would suggest we hop on a call. I'll join it with someone from the team, and we've been in the repository business for long enough to know the challenges of ingesting messy photocopy of a photocopy of a photocopy. So we can talk about that, but as a general matter, we're quite good at turning contracts into precedent and into good metadata that you can use for other purposes like this and obligation management and alerts and other things that relate to our other products. And we'll talk about pricing in just a couple of minutes. There's one more thing that I want to show off here that relates to verifiability, and I see questions are still coming in, so I promise I'll get to them. This becomes really important. So if I look at commonly accepted, this is for ads, non-sale and non-re-identification promise. I can go to see reasoning. This is nice because it's giving me some analysis between what's in the document and what we've done in the past. So this is sort of a synopsis of what has occurred from a recommendation perspective. But the one step beyond this is what you really want, which is the verifiability. Because especially the first few times you use the tool and maybe forever, especially when you see something that your gut would be inclined to disagree with, you're going to want to click on that. I have to switch views for a second. This is sort of limitation of Zoom. I apologize. I'm going to switch views so you can see what just happened when I clicked on that, as it took me here. We call this matching precedent. 31 documents match it. And in this case, the match, these things are worded differently. And everything is here so that I can go see which agreements conform to the recommendation. Now, perhaps the most important part is then what happens from there. This is what pulls you through into the precedent library or the repository if you're using it. And this is where you go all the way through to the document. I won't show you that part today because it's sort of one too many jumps, but it will go to this exact document. So if you're like, I still don't believe it, show me take me all the way through. You can in fact go all the way through at the document level to verify what recommendation you are receiving. Okay. I'm going to spend 2 more minutes here and then I'm going to close us out. I'm going to show you the trust center. I'm going to show you pricing. And then My colleague Dory is going to share an application survey. In fact, Dory, why don't you do that now, just so we don't run out of time? Dory's going to, if you are interested in this, this does cost money. We are a for-profit business, but I think our pricing is vastly less than every one of our competitors, bar none. Um, if you have Simple AI already, you have to turn on the precedent library. The only way you would get this already is if you have Simple AI and the SimpleDocs repository. If you already have those two products, then this can just we just need to implement it with you, and so it's not there's not an additional licensing fee. Um, Wherever you sit, if you use the Law Insider version of Simple AI, that's not a problem. We can talk to you about what that path is. If you use the SimpleDocs version, we can tell you what that path is. These are things that we can get into, but the survey that Dory is going to share is an application for us to determine who will be the good first candidates. Again, this isn't like a sales and marketing trick. We want to find the best candidates for the beta release of the product, and the best really means your use case in terms of company type, number of documents, sort of the volume with which you're reviewing contracts. We want to find sort of our North Star or our blue chip customers as the early ones so that we're mirroring the product based on your requirements. In other words, you will influence our roadmap if you are accepted in this application. Um, okay. Uh, Electra, anything else that you want to share here? I am going to share pricing slides in a moment, but is there anything else? I didn't mention other precedent. This is about seeing the inverse of so not what supports the recommendation, but what doesn't support it. And so in this case, it says never accepted, which means that there's only, actually there's zero agreements that conform to this. In a scenario where there might be two or three, I could certainly look at those, but what I really care about is why it is we've never accepted this in the past. So I could also similarly go to other precedent and it would show me the ones that don't conform or did not accept what is here. Electra, anything else that you want me to double click on inside the Simple AI tool?
I think we've covered, sorry, I think we've covered everything, and I'm just really glad to see such thought through questions coming through.
Excellent. Love to hear that. So let me, I think Dory hopefully shared the link with you
Yeah.
already. And now let me do two quick things um, and we'll let you all go. So in order to have precedent, we have to look at contracts. That means that you need to trust us as a vendor. And I can tell you that we do this for global companies, multinationals, public companies, defense contractors, pharmaceuticals, financial institutions. You can see some of our great logos on our website at simpledocs.com. I have spent a career in enterprise software. We take these things extremely seriously, and we know that we'll need to go through a due diligence process, and we welcome the opportunity to do that. Trust.simpledocs.com is our trust center. At the bottom is an FAQ that specifically goes into how we use AI, and this may be of specific interest to your due diligence team. Okay, let's talk about price. So here's how it works. The basic version is not relevant to today because precedent-based benchmarking and the contract intelligence layer is exclusively available through the Pro version. It's 279. I know this is like a novel idea that I'm on a webinar revealing our pricing, but we get to sort of play by different rules as a legal tech company from our competitors, which we which we're very prideful about. You can go to simpledocs.com/pricing and see this. In fact, if you do that, which I recommend all of you to do, what you will also see is not just these towers, but you will see a very rich side-by-side comparison of our different products. So basic, pro, repository, and document automation. So feel free to jump over there after the webinar. But the 279 version, it's a 5-seat minimum. There is some wiggle room there. So if you're sort of a 3 or 4 seat, we're happy to talk to you. But as a general matter, we limit it to five. Why do we do that? Is it because I know there's all sorts of like, oh, Lagora wouldn't take my call. We're not big enough. Generally, we don't operate that way. But for something that requires an implementation where we're integrating your data, where we're going through a due diligence process, we generally want to have some minimum commitments from our customers. But send me a note if you want to challenge it. Um, and the optional upgrades are precedent library is what enables this. So basically you would purchase SimpleAI Pro for X number of users, and then you would have a flat annual fee and it's nominal to turn on the precedent library. Or if you're ready to upgrade to a repository, that's flat fee as well. So those are pricing packages that we can share with you on a one-on-one conversation. But the Simple AI Pro, uh, let's see, notable. Um, I think that we're one of the first to launch precedent-based benchmarking, maybe one of only two in this market. We're certainly the only ones to post transparent pricing, which makes it easier for you to make a business decision around. Um, but this product is probably 50% to 40% less than our competitors. So I want to stand on that. And I'll tell you for a moment as we're running up time against time that I have spent a decade and a half building Law Insider. I have spent now 3 years building SimpleDocs. We have married these businesses together. Law Insider, as you know, and it's part of the reason why many of you are here, has been an incredible global resource for transactional attorneys for a very long time, which means that we have just incredible distribution. We are growing faster than ever. We are also privately funded. And the combination of having great proprietary distribution, having great brand equity and reputation, and being privately funded, we just completely get to play by different rules. We can package the way we want to package. We can price the way we want to price. These are high margin tools. So business is very good and very healthy for us. But we don't have the VCs telling us that we need to sell huge packages at huge prices. So I know that's a little bit of a sales pitch, but it's hard to be bootstrapped. It's taken us a long time to get to the place where we are now. And so I have a lot of pride being able to say to our customers, you are literally our primary customer. We don't have an investor that is swaying us in one direction or another. That is it. The survey should be up. And I encourage everyone that is interested to take it. Would also love feedback generally. So if you do not fill out an application, but you don't like what you saw today, I would love you to reach out to me at preston@simpledocs.com. And conversely, if it's not the right time, but you're just generally interested in what we do, or maybe you're interested in the basic version because precedent not yet, but you did like the other things you saw today. Feel free to go to the website and request a demo at simpledocs.com, or you can always reach out to me at preston@simpledocs.com as well. I see a bunch of chats coming in. It's probably some goodbye messages, which is great. But Electra, if you see anything else in there you want me to address. Yep,
All good.
Andy, red lines are limited to your playbooks only. Playbooks are not shared. I see Electra already answered that one. Dory has dropped in the application, so everyone should see that. Oh yeah, Jim, you see it right there, hopefully. Um, yeah, it's survey application, same thing. Sorry, crossing terms, but it is a survey that functions as an application. Um, excellent. Electra, any closing remarks? We're at time.
Thank you. Thank you all for coming and thank you all for all your questions. If anyone's got any further questions, please do not hesitate to get in touch. Dory, can we drop an email address in the chat for anyone who wants to contact us for more information?
Thank you,
Thanks.
everybody. I appreciate it. Lawrence, I saw your comment. We'll reach out to you separately. Thank you.